All right, ladies.
Sorry. No, you can sit.
Okay, fine. Yeah.
No, it's okay. I can stand. Broadly, how many stages are there in obtaining OC? You don't have to go through compliance and other things. How many stages of approval, and who is the corresponding approval authority if it is under BAYAPA and Panchayat, Gram Panchayat? They are not a Gram Panchayat.
Yeah, you're talking about the project approvals, right? You're down. Oh, okay. See, CC means, commencement certificate, right? Oh, you're referring completion certificate. See, the completion certificate is actually, no, completion certificate from whom you have obtained? Okay. See, commencement certificate is for at the time of commencing the project. I'll tell you, I'll come to that. There are 2-3 things which I wanted to explain. Commencement certificate, the developer has to obtain, after this columns, foundations and all those things. So it is ready for commencement. You can consider in that way. Then, after the commencement certificate, then the next one comes, what is that? Occupancy certificate after the project is completed. Without commencement certificate, the chances of getting an occupancy certificate is very less. You are talking about the planning authority. So you said the completion certificate is received. Now your problem is occupancy is not received. Occupancy, there is a lot of delay in all the project. I don't know whether I can say it loudly, because lot of money is required for getting an occupancy certificate. Many of the builders are not able to procure that. So probably, what I am thinking in the sense, like this we can also have a group discussion. I can try to invite government officials also in this. Unfortunately, because of the internal reconstitution of the ministry, as I said, BWSSP chairman, he changed yesterday. Those kind of things are happening here. So once at the right time, we can have a discussion. OC is a very important thing. Without OC, you may not be able to, obtain khata. Registration, the law says that without getting occupancy, as I said, what is the meaning of occupancy certificate? The project is safe to occupy. Project is ready to occupy. The project is safe to occupy. So the law says that you should not occupy a building without getting an occupancy certificate. But if I say that you should not go and occupy the building, you are the one only losing the money, right? EMI is there, then you will have to pay additionally rent somewhere else. Lot of things will be there. So the practical solution is you can possess the property. This is not the legal solution. A practical solution, you can possess the property, occupy the property. No, without occupancy certificate, it was possible, now it is not possible. You got clarity on this? Okay, fine. Yeah. Please. No, this OC, I think DKS has also mentioned certain things yesterday related to OC and khata and regularization of the property. Probably, we all have to go and meet him. Everyone has to, we gather together. These proprietors, what we can do, through proprietors, we will communicate to you. So these kind of sessions, if people goes together, they will also be interested. Like N.A. Harris has mentioned, RERA chairman. With RERA chairman, we can also have some discussions. With the different departments, we can also have certain, discussions. We have to create a group. That is what I wanted to say. Please, ma'am.
So
My name is 𝗕𝗟𝗦 𝗟𝗲𝗴𝗹. I'm a social media manager of a lot of groups in Bangalore and a lot of groups, Facebook, WhatsApp and a lot of things. So it's like a lot of questions come around these and I'm like surprised many don't even know the basic things. So I was going to in fact request you the same thing, like can we have some education sessions or some newsletter or some channels where people get to know, starting with basic, maybe probably then they can reach out to you for the queries further. But the basic education is something which is the need of the time because this act has come in place and many even don't know. I mean, there are many with the society registration, still with that act. So I guess you can probably, the group thing, please, I have sent you a message on your phone and if you create a group, please add all of us.
Hello.
I'm also so interested to, be with you guys, and if I can do something for rectifying these, definitely I'll do that. Now you all have our details, right? You might have got it from the registration desk. Please communicate to us. I'll appoint someone, from my team itself.
Check.
They will
Hello,
coordinate
check.
with you. If you are not getting any answer from my team, please let me know. Okay? Hi. Okay, whatever it is.
Thank you
Sorry,
for...
he was asking for a long time. Yeah.
See, it's a long pending project, almost 18 years or over. 1,000 apartments are there, 10 blocks are there. 10 blocks. They are saying that, Apex will be formed only after the third stage is completed. Phase-wise development is there.
Okay.
Correct. Apex is because for common area maintenance facilities, 𝗕𝗿𝗁 is there. That is one question, madam. One last, big.
Okay.
See, in the functioning of the association, what is happening is members are not coming forward, the owners. But according to Apartment Owners Act, I read that family members can be OBs. They have the voting rights. So these two questions we need some clarification so that if the owners are away from the country, their family members can be allowed. That provision is there in Rule 9. Could you please elaborate?
See, we need not have to depend on the act for this. See, you can execute a power of attorney. Authorizing, that power of attorney, through the power of attorney, you can authorize a person, whatever you want to do. He can act in your shoes. They cannot reject. No one can reject, but it should be a registered power of attorney.
Okay.
You see, whoever is purchasing a property, along with that, you can also execute a power of attorney. Again, I'll say that even though you are in your 30s, execute a will. That will also definitely help you. Because a lot of legal, in case if someone dies without executing a will, the headache is too much. I'll be getting work, but your headache is too much.
Correct.
Just a
Madam,
second.
that Apex formation, sir.
1 second, just hear this. We all think it is great to execute a POA. Fantastic. Please check whether the person is an Indian citizen or he has got overseas citizenship. If a person has got overseas citizenship and his name is Ramesh Padmanabhan, he cannot execute a power of attorney under an Indian law. He should get it apostilled and he should get it all sorted out at their end. Please be sure about that, because there should not later be a challenge that the power of attorney was not properly done. This is specifically in case of people who have taken other countries' citizenship. You can have a OCI card, but that doesn't mean that you are an Indian citizen now.
No, the person who executes or whom it is executed?
The person who gives the POA,
He should not be a...
if he is not of Indian citizen on that date, he has to execute it as per the laws of that country.
No, 1 second, let me clarify that. See, power of attorney means what? You are authorizing someone to act on behalf of you. Okay, so if you are authorizing your blood relative, for example, who is blood relative, as per law, your siblings are blood relatives, your parents are blood relatives, your children are blood relatives. One exemption is given, your spouse. Okay, for selling the property, you have to register this power of attorney. Whoever it is, you have to register this power of attorney. But if, register, it is related to the immobile property. Immobile property means land, property and all those things. Mobile property means your bank deposits and all. For dealing with immobile property, you have to register a power of attorney. In case, if you execute the power of attorney in favor of your blood relatives and your spouse, stamp duty will not be there. But if you register a power of attorney in favor of me, you have to pay stamp duty. If your value of the property is 3 crore, then approximately around 5%, 3 into 5%, how much? Around 15 lakh rupees you will have to spend for that. So that is the reason it is always better to register the power of attorney in favor of your blood relative. Coming to his point of apostilling the document, the law behind that particular point is, if you are executing a document outside the country, it has to be authenticated. If you are executing a document from India, it is not required. But registration is an exemption related to immobile property. But anything related to, for example, a name change. If you are executing a power of attorney from US, you have to go to apostille agencies or embassies. Embassy attestation is too difficult for you. There are agencies, because India and US and all are a part of Hague Convention. There is a convention. Based on that, you can go to certain agencies. These agencies are known as apostille agencies, APOSTILLE. So there you have to go and get it attested. Then once the document comes here, if it is related to sale of your property, then this document you have to take to the district registrar office. There it has to be again authenticated. So 2 steps is required. Okay, but what my point, his question is related to, can he appoint someone to act on behalf of him? He is the owner of the property. So execute a power of attorney.
Family unit definition doesn't help in...
Family unit, because owner means, you have also shown me. What is the definition here?
Includes a person.
Person includes a joint family. Okay. His form. So on a safer side, sir, my suggestion, wife, you have to fight among your people itself. Tomorrow if any problem comes, I won't come there. If you have some cardiac issues or something, you have to call your neighbor. So my suggestion always is to don't go with argument. As you pointed out, it is correct. But it's always better to have a power of attorney in your hand and then show to him. It's not a big thing. That is one. When it comes to your apex federation, okay. So there are 3 associations, 3 deed of declaration I understood, right? At least 3 phases. In that, every deed of declaration, the law says that bylaw should also be attached. Right? Deed of declaration is not a single document. It is annexed with bylaw. And I have pointed out earlier, it is your Bible or Gita or whatever you wanted to call. So bylaw says what exactly the rules and regulations, how to maintain and manage the property. Okay, so this...
If the deed of declaration is not executed by the builder, what can be done for that? If the deed of declaration...
That's a very complicated thing. So in your case, actually, builder is ready for all these things. Only thing is that an apex federation is not created, right? It's better you can talk to the builder, ask the builder to create an apex federation's bylaw. Apex federation. Because there are 3 associations, A, B, C associations. 10 associations. Okay, 3 or 10. There are, just imagine 3 associations or 6 associations. A plus B plus C plus D plus E is the Apex Federation. And this Apex Federation is controlling wherever it is required. So in your bylaw, there should be clarity. You should not give a lot of authority to Apex Federation also, because your apartment complex needs might be different. And this Apex Federations, what exactly they have to do? Probably the roads and common area maintenance, management, and a lot of things. So, why the builder is not agreeing?
After the third phase is over, I told. Third phase is not yet started also.
See, big, huge apartment townships, there are practical difficulties, I do agree. But, we can talk to, we can. If the builder doesn't agree, then we can send a letter to the builder, notice to the builder. All those done? Okay, you let me know which builder, what I can do, I'll tell you. We can do that, yeah. But you are clear about what to do. Apex Federation is there, bylaw is also required, you have to do. That is what RERA chairman, someone has pointed out. They have 10 towers. In that 7 is only completed. Then again the sanction is giving for another 2 without completing the third one.
Madam, can you just enlighten us on DOD, not conveying the DOD by the builder?
DOD is sorry please, yeah.
And what is the implication if it is not done, but how to do it?
Okay, so DOD is the constitutional document of the association which is registered under the Karnataka Apartment Ownership Act. The procedure I'll tell you. If you want to register an association under the Karnataka Apartment Ownership Act, DOD, Deed of Declaration, has to be drafted. What are the contents in the Deed of Declaration? It discusses about the project. This project is 5 acres of project. This has these many units. And every apartment owner is entitled or, his share is such and such, UDS. His super built up area is this. All these information will be there in the DOD. That is what I said, this DOD is a very important document. You will be getting only information about your property or apartment unit from your sale deed. You may not be getting a collective document, or you don't have a collective document which says that in this project A01 is such and such measurement, B01 is such and such, and B01 owner is entitled for 300 square feet, A01 person is. Why it is important? Because at the time of purchasing the property, you may not be having an option of verifying. Have you done any survey? Many projects I have seen that this UDS is not tallying with the available land. So I don't know what are there in this Alibaba's, whatever it is. But what I'm trying to say, UDS tallying is a very important thing. I forgot to speak about handover also. Handover is a very important thing.
But if it doesn't, the builder does not convey the DOD, what should be the...
Please don't use the word convey randomly. Convey means sale. You have to use this. You have to write in somewhere. Why you are selling your property again and again? You are the owner. If the builder is not executing, the word executing means builder is not, writing or signing that document, creating that document. What you have to do, that is what your question is. You can approach the court, you can send a legal notice to the builder. You can approach me. I have some solutions for that. We can do that. But, I have a suggestion to the government also. Now, the Karnataka Apartment Ownership Act says that everyone has to give consent for this. And in an apartment where 50 units, 60 units, it's practically possible. But what about an apartment with 1,000 units or 2,000 units? Before sale, it is possible. The builder can do that. Builder can easily execute a deed of declaration. But after sale means he'll have to get the consent from each and every 2000 unit owners. It is a practically difficult thing. This is the one people have to concentrate, not about KAOA and all those things. I really don't want to talk about that. That is this, government's job. My suggestions to everyone is that, this has to be amended. Yeah, you can see if all the owners are ready to come forward. If all the owners give consent, we can do that. I have done in an apartment where 1,980 units were there. It's a huge, work. But even then, people have coordinated. They have called them. All of them have.
But DOD was supposed to be, whereas it's executed by the builder to enable him to sell the apartments. But whereas owners have to execute, one second, let me just finish. Remember that DOA, that is deed of apartment, is something that the owners have to sign up for if you have to form an association. And now currently our association, which is an illegal board, has continued for almost 3 years without conducting any election, without conducting any meetings, is now insisting on a Form B and a membership. Now, as you said, DOD clearly says that we are all members, right? So why is a Form B required and a membership fee of 1,000?
That is a procedural thing. Every statute says certain procedures.
But in the KAOA Act, it is not said.
KAOA Act says that
Only
there
one
are...
rupee.
No, ma'am, let me complete. So in KAOA Act, there are two procedures. One is the deed of declaration, that is the parent document. The another one which is prescribed is an individual declaration.
Yeah, that is
Deed of declaration is a collective declaration.
Yeah.
Individual declaration, it is very simple that I am ready to, execute this deed of declaration. It is a consent form kind of thing.
Yeah,
the legal language is that I am ready to bring my apartment unit under the Karnataka Apartment Ownership Act. That's the simple thing. But what is the problem in giving?
But that's a simple thing which was said in Form B. So why was Form B not initiated by the builder when he went to register each owner's sale deed? Correct?
If the deed of declaration is already executed and the election is conducted and your body is in place, there is no need of exercising it again. But in case if they are doing it, I am not saying that it is a wrong step also.
Listen. The election was deemed illegal by one of our competent, legally qualified owners, Mrs. Bhagyalakshmi, who is also a member of the RERA, who said, from 2016 until 2024, she has filed a case with PHL, not paying maintenance. But now because of that case, she went to Lok Adalat and got a waiver of all her MC for the last so many years. And that has affected all the owners who are paying. So how do we address this issue? Whereas this illegal board has supported her because her advocate is representing the association now to fight with the owners.
See, the answer to this is that if the deed of declaration is already been executed and if you have already conducted an election and everything is in place, there is no need of digging it again. So that is one. In case if they are going to dig it again, there is absolutely nothing wrong in executing one more Form B declaration, confirming that I am also, what is wrong? Probably some practical difficulty.
First and foremost, PHL didn't hand over a complete project. No. Just get a broad guideline. Yeah, broad guideline.
No, ma'am. What he is saying in the sense, we cannot club all these together. Association formation is one thing.
Yeah.
And the other things, what she has done, she has taken an advantage of the situation
Okay.
and very easily,
Manipulate
everything.
Yes.
Many
But
people.
what about electricity now for us? We are suffering because PHL has not installed that substation, 66 kV substation. Earlier they said because of this lady's litigation, they could not proceed with it. And now we are still suffering. Today we had no power the whole day.
You send me what exactly the litigation. Let me go through that because it's a very fact-based issue.
And I have escalated all these issues to PAF since 1 year. Now, just now I spoke to Mr. 𝗓𝗏𝗏 also. I said, I have not had any response from your team. At least somebody should be able to guide us. How do we go ahead? I'm a non-resident. So when I come here, it does really affect me a lot. Because there is no proper authority to look into. There is no one we can escalate
I
to.
think I would like to respond to your issue back. Strictly speaking, we are not here to respond to public queries. We are here to respond to our members. Yes. If your members of BAF is different, you said we have not responded. That's not the case because legally, I have not seen anything on my desk which is lying around connected to your issue as on date. If you're speaking with Satish on a personal ground, then please don't come here and say that we have not responded. I think I'll take it up very seriously. It's not a fair statement. We are all doing work pro bono and we expect that decorum to be maintained. I mean, you can't come here and make these kind of loud claims. They're not responding. We have not, sorry, under any obligation to respond.
1 second. Sorry. See, this, deed of declaration, are you clear? You're clear about, I'm asking everyone, you're clear about which association, 1 second, you're clear about which association you have to form, how to form an association you're clear about, what you should not do also, at least that you are clear about, don't convey your land, you're the landowners. We have to take this slogan, this apartment land belongs to apartment owners. It is in a small undivided portion. Right? Okay, if you are clear about that, I think the purpose of this proprietors is served. And I'll definitely, sir. See, whatever queries ma'am is asking, deed of declaration is already been executed. According to me, 90% work is done. Right? If the builder can execute a deed of declaration in the initial stage itself, the law might have foreseen it actually. The law says that owner can bring the property. Before the sale, who is the owner? Builder is the owner. And the builder has brought the property under the act. So it is over. If there are multiple sales happened during that time when he executed the deed of declaration. Just imagine he executed the deed of declaration after 50 sales are over. 50 sale deeds are executed. Then he along with this 50 apartment owners are the owners of this property. So he will have to go and get Form B declaration from every 51. But the law says that before sale also he can bring the property. That is the best thing also. You have to insist each and every builder to register under the Karnataka Apartment Ownership Act before the sale itself. If we do that, if we insist for that, all this confusion will be over. Then on appropriate time, when you are ready to get the handover, you can constitute the committee, you can conduct the election, people will be there, you will be having a bylaw. If the bylaw drafted by the builder is not good, we can go ahead with amendment and make it a stronger one. All these can be done. Please don't, waste time on some consent letters. Form B importance is only that consent. Already it is done.
While you are all eager to ask questions, all of you had dinner? Yes. My humble sister has not had anything.
No problem.
Please.
I call them for their clarifications. I am ready. Ma'am, sorry, he is waiting for it.
It's a general question, madam. Regarding the validity of the resolution passed in general body, and also the
1 second, your association is under?
I am a member of this lab also.
No, I am asking in your apartment, which association, under which act?
It is 1960 Act.
1
minute, I will come to that. See, one is that.
Sir, 1 second, after.
Let me complete it.
I understood.
Mine is covers yours also. See, the validity of So, see, my question is for the validity of resolution passed in the general body. See, the fact is that, see, I belong to 𝗔𝗽𝗿 where 248 flats are there. So
340.
248. Okay. And whenever we call for a general body, only some 50 people, 30 to 50 people will turn up. So whether the resolutions which we are taking there, whether it is valid or not.
Oh, okay.
Yeah, number one. No. Okay, sir, let me complete first.
Okay, I understood. I understood that question.
I am all the way over here to ask her, not to you.
No, sir, please. Sir, please. Yeah.
So this is the one point. The second is, see.
Can I answer to this and then?
You give to everybody, sir.
No, can I answer to this particular question? And then, see, he asked a question and he is also pointing out that quorum is not there. Okay, so what happened here? 248 units. Association is not valid, that I can say 1960. Forget about that. Just imagine it is a 1972 association, a valid association. They called for a general body meeting. They have sent communications to each and everyone. 248 received it. Only 15 has turned up. Whose fault is that? Is it committee's fault or your fault? You are not interested to go there. It is your responsibility to go and attend the meeting. If you are a responsible apartment owner. In your sale deed also there are a lot of clauses which mentions this. Right? You are not going there and you are saying that only 15 has attended the meeting. They passed resolution. How can you say that it is unilateral? Correct.
Because there is no efforts, maybe now digital law also came, they can take
Huh.
through app, society app and
Yeah.
at least the things are, some people are having so much time, they take some useless decisions and they
The legal answer is in the sense you didn't go and
new act is bringing something to validate. Like I'm a finance professional, whatever decisions, complaints like MCA, there is a written called how many resolutions a company passed, they have to upload in the portal, MCA portal every monthly or yearly. Like that, all associations should have a compliance mechanism, regulatory body.
Correct.
What are the resolutions they passed, how much quorum is there, and 2/3 majority is qualified.
I understood completely because almost all the things in apartment, every day apartment owners are coming and say, see, this problem, the legal answer in the sense, as I said, the principle of estoppel comes. What exactly it says? You had an option to go there. You didn't go. And how strong is your quorum is also one point. So normally in a quorum, you have to give an option if the apartment owners are not come. If your meeting is at 10, if the apartment owners are not come, 1 hour time, a gap, you can give it. And at 11 o'clock, you can start it. How strong is your bylaw? We have to cross-check it. And as you pointed out, IT Act is very clearly mentioned that online meetings can also be. So please create a mechanism where every apartment, we can as a group, we can think about it as a mechanism. You are the one who can guide me well because you are technologically advanced one. What we can do for making the participation more? As she pointed out, she's an NRI or someone, she can also sit there, she can vote it. So those kind of mechanisms we have to. Legally, this association is not valid. This 15-1, what you have done, now if we challenge it, it is difficult to stand before law.
The question is, at least for the future, regulatory mechanism should be there.
Please.
At least if you make mandatory, the participation will be there. Otherwise, it won't be. I'm asking for a general. No.
Bylaw, yeah, that can be.
Bylaw specifically is stating that
In person.
In person.
Is there any provision in your bylaws? No, what I'm saying, some bylaws are specifically mentioning in person. So you put it for general body meeting and pass a resolution. That was enough for you. Old means? 1972? See, general body meeting is enough for that. Because it is a legally accepted mechanism as per IT Act. No, I'm not saying that you can create a new set of bylaw. I'm talking about the mechanism of voting online. That can be done. But for changing the bylaw amendment, for the amendment, you need a general body meeting. You have to call a general body meeting and put this forward. What are the amendments you want to make? You have to. 3/4.
Let me specify. The DOD clearly says if you want to edit the DOD, you need 75% of all owners present in person to agree to it.
That in person can be overcome through a resolution. That's what I said. That can be done. Then you just put it on online. You can do that.
Sir, I have just 2 words for you. I have to leave, ma'am. Just 2 words for you. 𝗕𝗿𝗃𝗧𝗏.
Thank you.
Because, ma'am, I have never seen a senior legal counsel. I have just 2 words for you and your team. 𝗕𝗿𝗃𝗧𝗏. It basically means I have never seen a legal counsel take time out to answer. You have a fantastic time. True. And we hope to continue to work.
Thank you so much. We will create a group, of course. Yeah. I got my energy.
On the same note, on behalf of Almond Tree Association, row houses and villains, and the entire gathering here, I really want to thank you, ma'am, and BAF, Mr. Ramesh Padmanabhan, for the illustrative session. Thank you. We have many more such sessions to change the ecosystem.
Please.
And for providing the platform. Thank you for the bottom of my heart. And thank you for all the refreshments. It really takes efforts to organize such a mammoth task. So we are loads of gratitude. And
we will continue with these sessions, definitely. Thank you so much for attending also. Any questions didn't I answer?
I have. UDS is not there.
Why? When did they execute the sale deed? When? Are you sure that there is no DOD? Okay. But at least the DOD they have. Just see that advantage of executing the DOD. In the sale deed it is not there. In the DOD it is there.
Ma'am, I have.
Okay, fine, sir. You just show to me the document. I'll see.
Ma'am.
You come.
Ma'am, I have one more query here.
Ma'am, I am from Parasmani Regency apartment for which you have drafted the bylaw. Somehow it has not gained any traction. And I have seen the bylaws. I have in fact made some suggestions to the bylaws. So I just want to know the actual ground reality of not registration.
That is another thing. There is a cooperative group. They are threatening everywhere. So this loophole people have mentioned, no, everyone has to sign. Right? Your property is also sold. Without, they had filed many cases against the sub-registrars. Criminal cases also. Saying that I hadn't signed this, but even then DOD is registered. Now sub-registrars are worried about that. No government officials will be, they will not be ready to come. So that is what sub-registrar office. Next Legal is the only one who is doing the deed of declaration, that too with a lot of difficulties. Yours will also be done. Give us some time. This is the reality.
Got it. And deed of declaration is to be signed by both the owner and builder.
All the apartment.
And one more quick question, ma'am, on the parking.
Sukanya is also very good in...
I'm Sukanya.
Yeah, I'd like to finish that. See, my doubt is our apartment has a registered DOD under Apartments Act 1972.
Okay, builder has done that.
Has done it. So everyone who's basically doing the sale deed is getting it signed. That is sorted over there. But then I am the next association member. Prior what they have told, we have sent this particular document to RWA. RWA is not accepting it. They have clearly told we do not
draft you are talking about.
Yeah, the DOD has gone. The election results have gone, everything has gone.
DOD is registered?
Registered. They have told we will not accept anything which is of 1972, only 1960 is what we will accept.
I can give you a case law. There is a direction to the society's registrar. Don't do this. A clear direction from the court.
They have sent it back.
Then you just coordinate with 𝗟𝗏𝗧. She will right away send it to you. Your number. Just in the group, I'll do one thing in the group. Certain legal points we will mention. I mean, some clip. So whatever I can do, I'll put it in the group. Be a part of the group. Right?
And certain other things that you have pointed out in terms of As you said, the committee is responsible, like the snake, the issue that happened. Now, see, this is maybe common area. Some of them, of course, putting their batteries, their whatever articles, wherever they feel like, in the common area. Even if the warnings are given, penalties are put, are we legally allowed to move it out?
After giving a lot of
Warning, penalty,
warnings and everything, you remove it.
Committee is not responsible.
You can also give an explanation mentioning that these kinds of things are happening. We are responsible for that. But send proper communication to the owner in case if you want a legal notice also.
No, in EGM we have got this approval and sent, put it on.
Car parking area is only for car parking.
Okay.
That you have to understand. If it is an individual house, in your car parking area, whatever you want, you can put it. But when it is a community living, whatever is meant for or that area, there you can put only that.
My final query on legal.
Can the DOD be revised?
Amendment can be done. Before the OC. OC is not a... You can amend it. OC is not a condition for, occupancy certificate is not required for. Yes, yes.
No, I have one final query regarding RERA and legality.
No, but your sale deed is not executed, right?
Sale deed is executed.
Executed, but occupancy certificate you didn't receive. Sale deed is done. Without occupancy?
Yeah.
Ma'am,
then you are lucky.
Ma'am, we are.
Who has to leave?
Shabir, sir, he's actually waiting.
Ma'am, only one small question.
Sir, has been waiting for a long time.
Shabir, thank you so much. You know, his performance was also very wonderful, no? Yeah, thank you so much. I'll keep in touch. Huh? Yeah. Tomorrow itself I'll call you.
Ma'am, one small question, ma'am. Yeah, please.
Final query I have in terms of RERA. The validity, as you said, is for 5 years. RERA warranty is for a 5-year period, right?
Warranty for construction.
Yes. Now, builders are playing very smart in this way. Whatever you're building, structure, clubhouse, one part. Rest of the common area, landscaping, swimming pool, all that as the second part. They are handing over the building and stating from that day and the OC date onwards, RERA, whatever warranty starts. This, if they have completed, let's say, only 2 years back, they still state, we have handed over. We have not accepted the handed over. We have formally written to them that we are not accepting your handover because of these issues. But they clearly state, as per RERA, we are through. We can't do anything.
No, handover you should not accept like, kind of a handing over a key. Handover is there's a lot of procedure connected. You have to cross-check all your sale deeds and a lot of things you have to cross-check. You pointed out the warranty issue. You capture everything in an agreement and then accept it.
See, as I said, I am the next. After 2 years, I have now taken over. Previous association, this has not happened. Now, what is the solution?
No, there is no point in saying previous and all. Now the solution already accepted.
They have also, no one has taken the handover. It's only a mail from the developer.
And then you demand for handover. You can just, is there any documentation which is mentioned that, project is handed over to you? Signed by you?
No, none of them.
I'll check it and then after that I'll give a solution.
Ma'am.
So some people are waiting for that. So I'm so, give me a second.